Dearborn National can't make proving own occupation disability benefits a moving target. Disability insurance carriers like Dearborn National don't make it easy for disabled policyholders to get the disability benefits they deserve or to stay on claim when the definition of disability changes from own occupation to any occupation. Let me tell you the story of Mr. Grouch, a Dearborn policyholder. He was disabled because of cervical and lumbar pain. He had radiculopathy and pain that radiated into his legs. He also had side effects of medication that he took for his pain. He applied for and paid disability benefits by Dearborn. He was paid his own occupation benefits and paid for 2 years. Now, the policy provided that after he had been paid for 2 years of own occupation benefits, the definition of disability changed to own occupation benefits. He had to prove that he was unable to do the material and substantial duties of any occupation. Now, what did Dearborn do? Did they renege on their promise to pay any occupation benefits? Well, of course they did. I'm going to talk about the tools that Dearborn National used to deny any occupation claims. Before the change in the definition of disability, they had his medical records reviewed by their in-house liar-for-hire peer-reviewed doctor. They concluded that he could work at his own occupation and he could work in any occupation. The second thing they did was to have an in-house liar-for-hire vocational evaluator, and they evaluated the file and determined, based on his education, training, and experience, there were other occupations that he could do. And they considered the restrictions and limitations assigned by Dearborn's doctors and ignored the restrictions and limitations assigned by his treating physician. So after they gathered that information, what did Dearborn do? They did what was in their best interest. They terminated his own occupation benefits and denied the further payment of any occupation benefits. What happened is they did that on purpose because they didn't want to be exposed to paying benefits, not only for the own occupation benefits, for the life of benefits through the end of the policy period. Now that was sneaky, wasn't it? Because they denied it in the own occupation stage. Well, what was the third tool that they used? They just stopped paying his benefits, and in violation of the ERISA regulations, they never sent him a denial letter. The fourth thing they did was they sent him to a liar-for-hire independent medical evaluator. Well, it wasn't independent, and of course that IME provider said that he was not only capable of working based on his restrictions and limitations in his own occupation, any occupation. He did a cursory review of the medical records, a 26-minute IME, and wrote a report that said, hey, you're capable, based on the physical requirements of your own occupation, that job. Now, Dearborn finally got around to issuing a retroactive denial of the claim. Now, what did Mr. Gross do? He appealed. But Dearborn wasn't done messing with him, because on appeal, they tied a bow on the termination because they had the file recommended by the reviewed by the infamous Dr. Marion. Google him, you'll find out what the courts think of him. But he's used to justify a claims denial. Of course, he agreed with the IME provider, and what did Mr. Gooch do? He challenged the denial in court. What did the federal court say about this moving target for disability? Well, the court basically said, no. So this is a California case, and you need to understand that in California, the standard of review is different because the state prohibits discretionary clauses. That means that the judge was able to apply the de novo standard of review, substitute his own judgment for that of the disability carrier. Now, that wouldn't happen if there was an arbitrary and capricious standard of review, as there is in many disability policies. The judge found that the claimant was believable. There was substantial evidence of disability based on objective testing, like x-rays, MRIs, EMG and nerve conduction study tests, and even physical examination findings. Now, the court also found that the frequent changes in medication substantiated his complaints that his pain wasn't under control. And the court also noted the side effects of the medication that Dearborn never ever considered. The post-denial FCE that he went in as part of his appeal was approved by the court. The court said, look, this proves the nature of his disability and the extent of his difficulties. And of course, the judge criticized Dearborn's VE providers' opinions because they relied on the wrong restrictions and limitations. The court said this was a moving target. The IME report is suspect. It didn't discuss relevant medical records. It didn't discuss the functional capacity evaluations. It didn't even discuss the requirements of his own occupation. And it was internally inconsistent. Finally, the court found that the good Dr. Marion's report was cursory and that it had failed to address all of the relevant objective findings on examination and the significance of his pain and side effects of medication. So the court handed Dearborn its head and found that Dearborn's evidence was not credible. The court ordered Dearborn pay the full period of own occupation benefits and to consider his any occupation benefits. Isn't that a wow type of decision? I've litigated a lot against Dearborn, and what is important is whether or not your case is an ERISA case or an IDI case. And in the context of an ERISA case, what's important is whether or not there is an arbitrary, capricious standard of review. And of course, what's also important is the quote-unquote evidence that the disability carrier relies on in denying or terminating your benefits. There are states, such as California, as I've said, forbid discretionary clauses. And that makes it, quite frankly, I think, easier to get your disability benefits. But that doesn't mean if you live in a state that allows discretionary clauses, like Florida, or that you're afraid that the disability carrier is just going to win because of that arbitrary and capricious standard, I think you should consider consulting with me. When I look at the conduct of carriers, I will normally find 10 to 15 reasons for claiming that they have violated the arbitrary and capricious standard of review. It takes a team, in my view, to get your disability benefits. It requires a skilled attorney such as myself to understand the medical, legal, and vocational issues, someone like me who can work with your doctor to address the basis for the carrier's denial, to get an IME if needed, or even a functional capacity evaluation, get your statement, and basically build a case. Because in an ERISA case, the appeal is the trial of your case. Call me at 727-894-3188 for a complimentary consultation to learn more about your claim for disability benefits from Dearborn. If I end up filing a lawsuit on your behalf, I'm going to be in federal court. And I'm not afraid to be in federal court. We're required to have a mediation in your case, and I am very skilled at negotiating with disability carriers, including Dearborn. So call me today at 727-894-3188 for a complimentary consultation and learn more about your rights to your disability benefits, taking on Dearborn National, and what you should do to make Dearborn and other disability carriers provide you with the financial peace of mind they promised you when they sold you your policy.